But in order to get sort of a foundation of how we get there, we have to start from a very early starting point, and that's Barron v. Baltimore in 1883. In Barron v. Baltimore, I'm going to give you the sort of factual setup of the case. Barron sues the city of Baltimore. Now, the reason why which he sues the city of Baltimore is because Baltimore decided to dredge the Baltimore harbor. The reason why they wanted to dredge the Baltimore harbor is because they wanted to make it deeper and more accessible by larger ships, thereby increasing trade to the city and just being an economical boon for the city. But in the process of dredging the Baltimore harbor, Barron, who owned a wharf, and I know probably most of you are from El Paso, you may not know what a wharf is. A wharf is simply another word for a dock that extends out where ships can be docked. Well, in the process of dredging the Baltimore harbor, the city diverted some flows of the streams, and in doing so, they made the wharf inaccessible. So basically what had stuck out into water no longer stuck out into water. So Barron was prevented from using his port as trade or for trade. So the question in this case, and the question that Barron puts forward, is whether the Fifth Amendment's prohibition of the just takings clause applies to, in this case, the city of Baltimore, but more applicably in a broader constitutional sense, whether that Fifth Amendment protection applies beyond the federal government. To give some background to what the Fifth Amendment takings clause means, the Fifth Amendment basically says that the federal government has the right to obtain private property through a process known as eminent domain. But if the government does so, it must pay just compensation to the individual whom it took the private property from. That's why we call it the takings clause. It's because the federal government and other governments can take private property away from owners, but only if the government actually pays for it. So they can't simply take it by fiat and deprive you of your property. You have to be given something in order to make up the difference of what that property supplied to you and costed. But we know that, at least at this time, 1833, that the Bill of Rights was only applicable to the federal government. So in this particularized case, Chief Justice John Marshall, whom you should be familiar with at this point, the author of Marbury versus Madison, simply replies that no, there's no real finding that the government, the city of Baltimore, should be made to have to comply with the Fifth Amendment's protection. And that's because the Bill of Rights don't apply to the states. The Fifth Amendment has to be understood as restricting the power of generalized government, but not of state or local governments. If the Constitution of Maryland does not include a similar takings clause, then this individual, Barron, can absolutely be denied his property, and it can be taken away by the states, however offensive that might be, without any form of compensation. And the place that Marshall finds this, looking at the Constitution, is very, very easy. He looks simply to the first 5 words of the Bill of Rights and makes his finding, and the court makes its finding based on that. And the first 5 words of the Bill of Rights, the first 5 words of the First Amendment to the Constitution is, Congress shall make no law. Because of that, Marshall says that if the drafters had wanted these protections to be applicable on the states, they very clearly, in the first 5 words, would have not called attention to the fact that this was a restriction on Congress and therefore a restriction on the federal government. If they had wanted to make it more broadly, they absolutely would have. But because of the language they chose, Congress shall make no law, the Bill of Rights absolutely are not applicable to the states. And in this particularized case of Barron v. Baltimore, Barron has no legal remedy available to him for being denied the prosperity that his wharf allowed him. So it's a very simple case in which the court lays down pretty clearly that the Bill of Rights, just absolutely as written, cannot apply to the states. Therefore, sort of ending the debate, of which was ongoing at this time, about whether these amendments were also applicable to state governments.